Today we are talking about estate planning questions and answers to finish the Estate Planning 101 series. So stick around and get your questions answered. Hello, and thank you so much for joining me for the last video of the Estate Planning 101 series. I am the Estate Planning Mom, and my name is Krista Hermans. I am an estate planning attorney licensed in California, and I help families with minor children protect their children and families through estate planning. Please make sure to click that subscribe button and hit the bell to be notified when new videos are released every Monday. And if you didn't see the first video in the series, head over to see what probate is and grab the free emergency contact sheet I'm giving away there. Today we are going through your questions and answers on estate planning. How do I avoid probate? That's a great question. Essentially, when somebody doesn't have a will, or when they do have a will, and they have any assets that are in their individual name that are payable to your estate, the estate would then have to go through probate court. Many people use a fully funded revocable living trust, and when I say fully funded, I mean they have all of their assets moved into the name of the trust, houses, accounts, retirement, life insurance, whatever that is. They're all in the name of the trust, so that when somebody passes away, they essentially don't have any of those assets in their name. And check on video 3 in the series on trust to learn a little bit more about those. Next. I have a will. Isn't that all I need? Well, it really depends on what your planning goals are. If your planning goals are that you want your estate to have to go through probate court, to have to pay all of the costs associated with it, the time that goes through it, and it being public, then yes, a will is all that you need. But if you're looking for something that's going to be less money to have to go through, that's going to be private and it's going to take less time, then you might be looking at something like a revocable living trust to be able to help you with your planning needs. I am divorced. So how do I make sure my kids will receive my estate and not my ex-husband? And this is a really great question, especially for families that are concerned about their ex-spouses maybe not doing things that they would want for their children, or at least with the money. So one of the options that you have is by doing a revocable living trust, you can identify a successor trustee. So this is somebody that you would identify to be able to manage your trust for you when you were to pass away. And then they would be responsible for your children's inheritance from your stuff. It wouldn't necessarily just go to the children's other parent, whereas if you didn't have a trust, it could go to that other parent because they would likely be the guardian of the children and would likely have access to all of their money to be able to do what they wanted with it. Whereas when you have a trust set up, like I said before, you have a successor trustee that you've identified, somebody that you trust to manage the money for your children, and it doesn't have to be the other parent. So it could be, anybody that you choose, a sibling, a parent, a friend, but somebody that you trust that would be able to manage that money for your children. And it wouldn't have to go into the hands of the other parent to be able to manage or do what they wanted with. Okay, next question. At what age do I need an estate plan? And I'm going to say this, it's going to be 18 years old. As soon as somebody is of legal age, they have the ability to sign legal documents such as a durable power of attorney, advanced healthcare directives, HIPAA forms, giving authorization to agents that they identify to be able to make decisions on their behalf. Parents oftentimes don't understand that when their children turn 18 years old, they lose all of the ability to make decisions for their children because they've now turned 18. Now, estate plans aren't necessarily going to look the same for an 18-year-old and maybe somebody that's 40 years old. There could be different planning in place, but some of those same documents, like the ones I just mentioned, the power of attorney, advanced healthcare directive, HIPAA authorization, are common forms that could be used in both estate plans. There might be some different forms in there depending on what their planning goals were at that time. Okay, next question. I don't want my minor kids to receive my estate if something happens to me. What can I do? So this is very similar to the one I said about the ex-spouse. But depending on the type of assets that you have, when, if a parent was to, or if both parents were to pass away, and the children were to receive the funds and they were minors, they couldn't actually receive those funds until they were 18, at least in California, until they were 18 years old. And then at that point, they would receive it all in one lump sum when they turned 18. So depending on what your planning goals are, if it's really just to protect your children in receiving that money at ages that you would want them to, then a revocable living trust would allow you to set up however you wanted it to be distributed to them. So like I said in the trust video that I did before, which is video number 3 of the series, you can set up a revocable living trust that would have sub-trusts for your children, so that if something happened to you and your spouse, your children could get their portion of their inheritance at ages that you set, so maybe 25, 30, and 35, rather than receiving all of it in one lump sum at 18. Next question. I am single and have life insurance with my best friend listed as the beneficiary for my children. How do I make sure the money goes to my minor children? This is a really great question, and I see it a lot when somebody comes in when they're single and they don't list their minor children on their life insurance because they know not to list their minor children on life insurance, but then they list somebody who they think will have absolutely the best intentions for their children, but there's no instructions on how the money is to be distributed for their children. So by having a revocable living trust, you can actually identify somebody, it could be that same person that you would want to distribute the funds for your children, but what the trust is going to do is it's going to allow you to set up the instructions in a legal document that's going to say specifically how you want the money distributed for them. Because if you just list somebody else as a beneficiary and you say, oh, well, they'll do the right thing for my minor children, they have no instructions to be carried out onto how you would want that money distributed. It literally would just, go into their hands to be able to do with what they want. And while you think they would have the best intentions, you don't know. And there's no instructions holding them to make sure that they follow those instructions. Thank you so much for joining me through this Estate Planning 101 series. Don't forget to click that subscribe button, hit that bell, and please comment with any estate planning questions or comments you may have. Thank you.